SJC-13222, Michael D. Cavanagh v. Lynn A. Cavanagh.
Attorney Goldman, when you're ready.
Thank you. Madam Chief Justice, may it please the court, Jeff Goldman and Morgan Lewis, with me is my colleague Emma Hall. We have the pleasure of representing Lynn.
I'm just going to ask you to pull the microphone a little closer to you.
Let's see that. Thank you, Your Honor. It works. Your Honor, the legislature passed the Alimony Reform Act of 2011 in order to prevent cases like this one. If you look over the transcript, which I respectfully urge the court to do, you'll see this is not a case, and now I'm speaking about the issues of alimony and child support, in which there were many disputed issues of fact. There's no closely held businesses with contested valuations. There's no offshore trusts. Parties got their income from jobs, compensation, and with some minor exceptions to be discussed, were set out in their pay stubs, in their W-2s, and their 1099s, and in their retirement account records. And while we may have some differences about what the husband's full income is, those differences arise from the way different forms of income should be treated, not whether the income in question exists. And nor is there any real question in this case whether it's a type of case where alimony would normally be warranted. It was a 21-year marriage. The wife supported the husband while he earned a professional degree and helped him pay off his student debt. Family income was well over $20,000 a year, and now the wife makes $30-something thousand a year. What the legislature wanted when it passed the Alimony Reform Act was that in cases like this, there'd be no good reason to go to trial because the window of potential outcomes would be narrow. If, in this case, you use the income of the parties as determined by the probate court, 32.5%, half of the 30 and the 35 of the difference would have been exactly $1,200 per week. Now you can look at the numbers with tax adjustments and bring that down, and you could argue it should be 35 or 30 or even 25. But that doesn't make the window very broad. Maybe you get between 1,100 and 1,300. Maybe you make an argument that it's exceptional, it should go to 1,000 or 1,400. But it's in a relatively narrow range where the parties are incentivized to settle the case. Here, after trial, the husband took the position that total support should be $492 a week. That's 13.3% of the income differential. The probate court awarded $650 a week. That's 17.6, I think, percent of the income differential. So you're way out of the range that the legislature was anticipating when it passed this act. As I point out in the briefs, as we point out in the briefs, and as the Guidelines Committee states in the most recent version of the guidelines, this falls into the category of cases where the wife would have been better off substantially if the marriage had no children.
Counsel, I don't disagree with you necessarily that this is problematic, right? I mean, I did read the transcript the way you suggested, and she quite clearly, and it seems that there was testimony at trial, that this was what they decided to do when they got married. Mm-hmm. She'd stay home, take care of the kids. The issue that I have, though, is when we're looking to the plain language of 53C2, and you're asking us to take an interpretation of to follow an interpretation that we would have to go to a definition that it's not the plain and ordinary definition that you'd find. You'd have to go into like the 3s and the 4s. Tell us why that makes sense. I understand it makes sense that there are other provisions of the Act that contemplate that both alimony and child support can be awarded in appropriate circumstances. But looking at this, just the language of 53C2, is it a bit of a tortured kind of definition you want us to infuse into that language?
I prefer awkward, but it is an unusual, you have to assume, and I think it's fair to assume, that the legislature goofed a little bit in using that language. it would have been certainly clearer to put it another way. But I also think it's utterly clear that the legislature didn't intend for the outcome that happened here. So there's two ways around, I think. There's the way that the guidelines, the present guidelines especially, have hinted on resolving this. And there's, my way, our way, which we respectfully think more effectively accomplishes the legislature's intent.
And when you say the guidelines, is that used, fixing the alimony first and then turning to child support?
The guidelines, if I understand them, currently say is it's up to the probate court. You should at least, I don't know if it uses the word should, but it says it's appropriate to consider child support first and then alimony first and then look at them and decide where you are. And of course, that's not what the probate court did here. And if it had, I respectfully suggest it would have come up with a result much more in the range that the legislature intended. The reason I don't think that's the best outcome of this case is that, first of all, it puts a big burden on the probate court, which I think is what the legislature was in part trying to avoid. And second of all, it takes that narrow range of outcomes and broadens it. And it does so in two ways, because in a situation where one spouse made most of the money and the other spouse is taking care of the kids, child support alone would be less than alimony alone. So we're now below the bottom. On the other hand, if you take a situation the same way and you do alimony first and then child support, you go above 35%. So you're almost, you're still going to capture the right range, but your range is going to be, I would suggest, broader than the legislature really wanted when it passed the statute. Mm-hmm. I do think that that's the second best resolution of this case, though.
Isn't there a third way the legislature fixes this? I mean, do we normally engage in this awkward construction that you're suggesting in order to fix what we, in hindsight, think the legislature wanted?
We certainly don't prefer to, or I don't think the court prefers to, but there's obviously lots of Massachusetts statutory interpretation cases. We just heard one, there was one last week about the possession of a gun. In sort of picking which one to cite, I used one of the cases about early release for medical parole, of which the court has had several. And the reason I chose that is because the court was looking at a statute that on its face left a lot of discretion. And it says, listen, I'm quoting now, this is the Malloy case. Timely release was of great importance to the legislature. The legislature certainly did not contemplate, as the Department of Correction argued, that the timing of the release would be left to the DOC's discretion. So when you have, I don't think there's a reading that says you have to do just child support. The guidelines don't say that. Even the previous version of the guidelines realized that was wrong. So you either have a situation where you got a lot of discretion from a statute that was supposed to confine discretion, or you reach a little bit for a reading of this one isolated word in the statute that seems out of place, that construed the way the probate court construed it is respectfully absurd.
So what's going on? Because it seems that you, as you point out, subsection G seems to make C2 impossible to implement, but most probate and family court judges, are they just setting alimony first?
Your Honor, I respectfully had never been in probate court before this case. It's a pro bono case for me, and I don't have the subject matter expertise to know what most probate courts are doing firsthand. I've tried to survey that, and what I've come up with understanding is there's a very wide variation across the state and from judge to judge about how this is being interpreted, and it was a substantial issue before the Guidelines Commission in its most recent.
But I guess you'd say that if you take into account subsection G in common sense, it would be an absurd result. Without the child support limit,
Right, right. You have a contemplation for contemporaneous orders at the same part as, if you read the statute the way the probate court did, an impossibility of contemporaneous orders.
Counsel, I don't want your time to run out without, I know you have other arguments about what ought to have been in the pot to consider for
Yes.
appropriate, but I don't want to miss an opportunity to talk about the emancipation issue, because that's an important issue to me. Why isn't that an appropriate determination here? And I'm gonna use something about the oldest child's emancipation to make my point. At some point later on down the line, the court found, and I believe you stipulated at trial, that he was emancipated at the time of his graduation.
Correct.
And that entitled Mr. Cavanagh to reimbursement for those child support.
I don't think I conceded that he
Well,
was
I don't know
due
that you
reimbursement,
wanted to,
but that he was emancipated,
ordered,
yes, Your
right?
Honor.
He was
Yes.
ordered and said that
Yeah.
for that period, he shouldn't have been paying. Why doesn't it make sense to presume emancipation in this sense? That all of this stuff in the record seems to suggest that the second child is being taken care of by the military. There's even that email that said, hey, if you're claiming them, don't claim them. There was testimony by Mrs. Cavanagh about how he doesn't come home at all that much, right? So somebody's taking care of him. Why wouldn't it be more appropriate to say he is emancipated, and if down the line there's some difference or change in circumstance, then you can come back and say, oh, no, he really wasn't emancipated. But based on all of the evidence that was in front of the trial judge, why isn't that a proper conclusion that he's emancipated?
So I'd answer that question in two parts, Your Honor. First, if we were looking at this case in the absence of a separation agreement, the arguments you made may be perfectly appropriate. And I'd, of course, have as you saw, contrary arguments for why
I'll
West
give it
Point-
to you. The separation agreement says in the military, and you're not agreeing that he's in the military for purposes of attending West Point. But why isn't that a proper construction by the trial judge that he is in fact in the military, because it has all the earmarks of being in the military, including being taken care of, including a stipend?
Just to clarify the record, the stipend is a West Point term of art. It's given and then taken back. So that he's not paid a salary like he
Okay.
would be if he'd enlisted. But more broadly, Your Honor, the separation agreement, if you read it, seems to contemplate the idea that the same child would get a scholarship. He's incredibly academically talented. So the separation agreement has all these provisions about how the wife doesn't need to contribute to the college, and how the college contribution is independent from the from the obligation to continue child support. So respectfully, what our position is that this is not an issue of abstract law, where you're looking at it afresh. You're trying to effectuate the terms of the parties' agreement. And under the agreement, it's pretty much clearly contemplated that if he gets a scholarship, child support continues.
But if he's emancipated, it doesn't.
Correct, but
That's the issue. So why is it that the trial judge was wrong in concluding that for purposes of the agreement, he's emancipated?
well, I don't think that it was. It doesn't say. The agreement's confusing on this. I don't think it's an issue that could have been fairly resolved without recognizing there's, as I say, a latent ambiguity in the separation agreement. You got military, you've got college. What did the parties think? And then really, that's what's important here. It's not an issue of abstract law. Emancipation is not from the statute, it's from the agreement. And my position is that the judge failed to properly resolve the issue because she did not consider the evidence about what the parties wanted when they signed it. If she'd listened to that evidence and she'd said, I hear you, Mr. Goldman, but I think that this falls on side B, not side A, I might not appeal. But she didn't do that analysis. She didn't determine what the parties really intended, and that's what I think she should do on remand. I'm running out of time. I could start on the privilege, but I won't detain the court unless there's further questions. Thank you, Your Honor.
Thank you. Okay, Attorney Dargy.
Dargy.
Dargy,
Yes.
sorry, thank
Hello,
you.
good afternoon. May it please the court, my name is Ann Dargy, and I'm appearing on behalf of the plaintiff appellee, cross-appellant Michael Cavanagh. And while we do have a cross-appeal, and I certainly, we argue that the court abuses discretion in the issues raised in that cross-appeal, I do want to address some of the points made by the appellant's counsel, particularly as it relates to this interaction between the award of alimony and child support. I think that the legislative intent is in fact quite clear when we look at the breadth of the alimony reform statute from 2011. The the legislature continued to be clear about the fact that the an award of alimony should generally not exceed the need of the payee, and also added durational limits and added restrictions on certain sources of income. Globally, the 2011 alimony reform statute gave better protections for payors of alimony, and I think that's an important distinction to be made when we have arguments relative to legislative intent. A reading on the whole, again, of this statute suggests that there were concerns prior to the reform that there were inequitable awards of alimony being made, particularly as it relates to the double calculation of the income of a payor. The sort of broad stroke statement that a person who is childless versus a person who is not childless, that the alimony award is, well, for lack of a better phrase, that there seems to be an equal protection argument, I think is a fundamental fallacy, because
It's a big picture, child support and alimony. There's four types of alimony, first of all, under the Alimony Reform Act. And secondly, and more importantly, they're getting at two entirely different things.
yes, I agree. They are.
One limit the other by definition in all circumstances, if they're getting at two different goals.
Because you have only one source of income. The child support guidelines themselves deal with one income. The initial guidelines that were the subject of this case are the 2018 child support guidelines. They considered income up to $250,000 a year. The new guidelines up to $400,000 a year. So if we're to make an alimony order on the same income that's used for the child support, you've essentially double counted this alimony, resulting in an inequitable.
But we don't know if it's inequitable, because the entire issue is whether or not the burden on the payor would be disproportionate to whatever the income happens to be. There was no analysis of that. It was just, you don't get alimony because you're paying child support. So we don't even know if it may very well have been a number that might have been an argument for it's inequitable. But the problem here is there was just a categorical denial of alimony based on the fact that child support was being paid. And, you know, to Justice Lowy's point, isn't this the very paradigm of why general term alimony is supposed to be awarded? I mean, you have a spouse who stayed at home, who raised the children, who helped put them through school. The incomes are disproportionate. I mean, yeah, I know you could say, well, she got a house and she got a payment from the 401k, but I suppose somebody could turn around and say, so what? She's a young woman. She's only in her 50s. So there's a long time here that's left to live, hopefully. How is she supposed to support herself now?
Well, I think for your second point, I think that the asset division is an important consideration, because she was given an essentially mortgage-free home, and she had a significant retirement account resulting from the divorce. So then we have to talk about her need. An alimony award can't be addressed without discussing the need. And so her need is going to necessarily be impacted by the asset division from the divorce. So she doesn't have a mortgage to pay. She doesn't have, some of her retirement concerns are her own. And there was also testimony, and this is important in many probate cases, and many probate judges have to make this assessment. And I will say, having been counsel on many alimony cases, one of the things that has to be considered is an ability to earn income. And the mother was quite clear in her testimony that she has the ability to work as a teacher, and she historically has been a teacher, that she has the ability to
She has, but all of these issues weren't really played out because they were not at issue in the case. And that's the problem here, right? I mean, because there was also testimony that her income to be a teacher was limited by the fact that she didn't have all the certifications that she needed. And it was going to cost additional monies to go get those certifications that she didn't have. Isn't that all the stuff that we want the judges to consider as to whether or not maybe an award of alimony would have been appropriate in the first instance?
I think that if this was a case where there was either a previous award of alimony, which in this case there wasn't, the mother had waived it in the first instance, and I would also note that she waived the ability to include the income from Bay State Medical Center that the father was receiving, so that would also have to come off the top when we have an alimony conversation in this case. I think the short answer is yes, of course. We would always want there to be a global sort of view of what the circumstances, the particular circumstances of both parties are. That having been said, she again isn't entitled to an increased standard of living beyond what she had at the time of the marriage. She continues.
Those are all really good points, but with the probate and family court judge saying, if I've got the section right, no, this is C2, I'm not considering all of that whole dynamic, that's the problem. I think we do want the probate and family court judge to consider everything you said in the big picture.
But I think she's bound at that point, or any probate and family court judge is bound at that point when they've considered all of the income. And as you know, we've certainly appealed her calculation of Mr. Cavanagh's income, but she, I would say, for lack of a better phrase, pulled out the pocket handkerchiefs to find every ounce of income she could to use as a to calculate as the child support guidelines. The guidelines are presumptive. There is still an unemancipated child, and she used all of that income in her calculation of child support.
But
where or how could she have then used other income
that's
for
the
an
problem I
alimony?
have with that, counsel, is that the all those factors that you were suggesting should have been considered in whether or not to award alimony were just not considered because the judge did the child support math first. And it just seems to me that that can't be what the legislature intended, that whatever equation goes first dictates whether or not you consider the totality of the party's circumstances. It just seems odd that the choice of doing one equation first is the driver.
But I think the trouble is if you were to do the alimony equation or calculation first, becomes even quite frankly more problematic, because the alimony calculation, unlike what I think is being somewhat suggested here, that the alimony has a presumptive calculation, which it doesn't. And in fact, the statute gives, and I note in my brief that we've moved the needle as it relates to the percentage of the income, that the statute says 30 to 35%. We're talking now more about 25 to 27% given the tax changes. That being said, the alimony isn't presumptive. She isn't automatically entitled to it. Certainly it's a case for it, but she isn't automatically entitled to it. And so what is the number? The number would be based on her need. And so then if we look at her need, could the judge then reduce the child support to meet, and I think what the judge could do is would give her some income from alimony and then factor that into the child support guidelines and run them that way. I don't know that you'd see her making a significant, I don't know that that would make a big difference in what she would otherwise be entitled to.
The problem is that we just don't know. The judge never struggled with, well, let's see what the alimony calculation first goes.
Right.
And the tax consequences, and then look at the, let's do the child support first and the tax consequences, and then make an informed assessment as to what in this situation is the best reason. Here it seems like the judge just did the math for the child support first and ergo said, I've considered all the income, so
Well, which the
that's
judge is
it.
permitted to do under the statute.
But
And
there's
so-
one other implication to that, though, is that right now, very soon, 2 of the children are going to be emancipated. You've got a younger son who is still yet to go to high school, but the issue may very well be that if we took what the judge did in this case, that there's a finite number of years to which child support is going to attach. And it very well may be that the wife has continued need past that. So if we take this construction and say, okay, as soon as the third child hopefully matriculates and graduates from college, that, you know, hey, Mrs. Cavanagh, your needs are all set, we could very well be wrong about that without this assessment.
I would respectfully suggest that that makes sense as far as a process, because child support fundamentally is designed to meet the needs of a child. It's a presumptive calculation that isn't based on virtually any other factors other than the parties' respective gross incomes. Actually doesn't, with the exception of health insurance and other support orders that are in a court order, it doesn't ask for any other reducing factors. So this child has the right to be supported to the extent that the law allows, which is these child support guidelines, which this child, you know, received, with the aside that we think it was still a high. But at that point, when we move into, in this case, which very well may occur, an alimony calculation, the mother's need will be different, likely reduced, because this child isn't at home, this child's emancipated and ostensibly living independently, and then the alimony would be reflective of what the mother's need at that time. And I think that's a more reasonable and, in fact, practical way of looking how we assess support of a spouse. To suggest that there would be some amount, even post-emancipation of the youngest child, some specific amount, I think isn't true. I don't think there's going to be, here you automatically have a 27% difference in the incomes. There are a lot of issues with that moving forward after the emancipation of the child.
Well, but it doesn't take into account that there is need now. There is need now, and that was the testimony, right? I mean, there was testimony about the fact that she was still driving a car that was the marital car, that it was on its last legs. Mr. Cavanagh had the benefit of 2 cars, that she was heavily in debt, and credit card debt, because she was using that to finance the schools, or at least for the youngest child. I mean, so there's need now, I guess, is part of the reason why I'm wondering why the trial judge couldn't do this at the same time.
I think and having been at the trial, I think that part of that issue is that the need to some degree was artificially created. You see in the record the very extensive contempt hearings that were had by the mothers.
The judge never, maybe, but the judge never got to that point. I mean, the judge is rigidly dealing with C2. I mean, maybe,
But I think
never got to that point.
But the judge was within her scope of the statute in making the determination that she did. She used all of his income for child's purposes.
If C2 means what it says, what does subsection G mean?
I would suggest that subsection G is really designed as a way to give the probate and family court, which across the board, in all cases in probate and family court, you see that those courts are granted with a tremendous amount of discretion in certain situations. It's somewhat the nature, and I think it's a very unique nature of the judges in that position. I think that subsection G acknowledged that there's going to potentially be interactions between child support and alimony orders. In this case in particular, that wasn't what the judge was looking at. The parties only did child support at the outset in their separation agreement. The wife at that time and the mother in this case effectively waived her certain levels of income for alimony and child support into the future, but there wasn't an award of alimony at the outset, and there wasn't that interaction at that time. The father was paying child support, and the judge simply continued what the parties had previously agreed to in the manner that they had previously agreed to it. I think that in the future, to address the future point, that if we're the mother to come back and seek additional support, which she very likely will, the emancipation of the youngest child, it will be under the set of factors that your honors have suggested today that need to be reviewed. Her ability to earn, her, in some cases, in this case, willingness to earn, and what her actual need is. She did, to some degree, create an artificial need by taking a home equity loan to pay for a private school tuition that the court told her she couldn't do. And both the father told her she couldn't do it, and the court said, no, ma'am, you can't enroll your child in this private school. There isn't an agreement by the legal custodial parent, and she did that anyway, causing herself, unfortunately, more debt. It's unclear further in the record why she wouldn't have used any of those funds to fix her car or to buy a refrigerator or to not use her. I mean, some of it was to some degree, unfortunately, a bit theatrical, and I don't think necessarily credible from the judge's perspective. But the judge didn't need to reach that point because the judge did what it needed to do under the statute with respect to the child support order. Realizing that my time is up, I just want to make the point relative to emancipation that the specific factors that the parties agreed to in the separation agreement, this is in Record Appendix, page 494, all of the factors that the parties set forth all deal with the idea that the child will at some point become independent. The child's no longer dependent on the parents. I think that's was made very clear in this case. A review of mother's financial statement makes it clear in this case that she doesn't have any output or support for the child in West Point at this time. Other state courts have certainly found that a child enrolled in a U.S. military academy is emancipated for those purposes. Certainly were the child to unemancipate at some point, although he is now through his second year at West Point, that could be dealt with at that time. With no more questions?
Okay, thank you
Thank you.
very much.